So, welcome everyone, the people who are going to watch this video after I have uploaded it in the YouTube channel. Thank you very much. Today is 7th October 2024. Welcome to this civil litigation November 2023 paper. Today I'm recording because there's no participant. I wanted it this way. The people who have been invited have not attended today, but anyway, I must continue. So, today is November 2023 civil litigation. We start at question 2. So, civil litigation, if we want to pass, you must do the following. Read Civil Procedure Rules 2010. Know how to draft documents, plaints, petition, originating summons, chamber summons, and know where they apply. Yeah, generally those two. So subscribe to my website. In the website, I've researched the civil litigation question from 2008. Yeah, 2008 until 2019 is combined document, but I did not do some drafting, which I wanted them to form part of the drafting class. Then June 2021, there was no exam in 2020 because of COVID. 2021, June 2021, November 2021, April 2022. Then ahead of exam last year, I did classes for October 2022 and March 2023, and they are uploaded on the YouTube channel by exam preparation website. So if you want to see the research, go to the website www.byexampreparation.com, open an account, go to the dashboard. There are notes, there are past papers for each subject from 2008 until April 2024, and there are the Q&A. In civil litigation, I've already said the subject which I've researched, which is you only use 800 shillings, and the papers you can't download, it's read only. So also see testimonials which are there. So I usually do these classes because research is a lot of work, but between the YouTube channel videos and the papers uploaded on the website, take precedence because that is written document. It has been done thorough research over the YouTube. So this one I usually do them as a stopgap measure before the exam. And also it's good to also state that there are no best and worst performance for this subject. In November 2023, there is no best and worst. So this recording is very, very important if you are doing civil litigation in November 2024. So watch. I also talk about other things that have not been asked in the question, like prediction. I also cross-reference on the past papers. Yeah. So welcome all, and welcome. Subscribe to my website. purchase papers, subscribe to my YouTube channel, join the followers on Facebook, on Twitter, and also join the website, by exam website, WhatsApp group. Yeah, which has three purposes. Your journey to becoming an advocate, you need relevant information. I share there. Legal jobs and legal updates. So let me go to it. Yeah. So I read the question. Question 2. Juliet filed a suit against Peterson seeking maintenance of a minor. On 27 May 2021, the trial magistrate issued some maintenance orders against Peterson. Agreed by the said ruling and order, Peterson filed an application seeking for review of the order issued on 27 May 2021. On 4th 2021, in a well-reasoned ruling, the trial magistrate dismissed the application for review. Again, aggrieved by the ruling of the trial magistrate delivered on 4th May 2021, Peterson filed an appeal on 30th 2021. A reading of the memorandum of appeal by Peterson reveals that is challenging both the ruling dated 27 May 2021 and another one dated 4th November 2021. Juliet has raised a preliminary objection challenging the competence of the appeal. The preliminary objection has been argued and a ruling date has been given. You are the judge's legal researcher. He has requested you to prepare a draft ruling. So, if you are to answer this question, you must know, first of all, what are the contents of a ruling. What are the contents of a ruling? So the contents of a ruling, of course, they are found in the civil procedure rules. The contents of a ruling, of course, is the heading, the facts, the issues, the submission by the parties, the analysis, and how the judge found the disposition. Yeah, so you must know the contents of a ruling, how it looks like. So many questions have been asked on how to draft a ruling or a judgment. A judgment look at the same way as a ruling. Yeah. So Order 21, Rule 3. Let me open that one and project. Civil Procedure Rules 2010. So So let me share. So if you look at Order 21 Rule 3, it says a judgment pronounced by a judge who wrote it shall be dated and signed by him in an open court. So, context of a judgment. Judgment is defendant shall contain concise statement of the case, the points for determination, the decision thereof, and the reasons for such decision. So, Order 21, 3 and 4 talks about the context of a judgment. And also the context of a judgment is the same as the context of the ruling. So you must know how to do a ruling or a judgment. So, yeah, that is the first thing. Then you must know now, let's now go to the drawing a judgment and a ruling has been asked many times. But now let us go to the content of this question. So, Juliet filed this case for maintenance of a minor. So the trial, of course, children case starts in the magistrate court. So, children magistrate court. So, the trial magistrate issued a date. Remember, I said in the last class that timelines are very, very important in civil litigation. So on 27 May 2021, the magistrate issued a maintenance order, made a ruling. Yeah. So then he reviewed. After he reviewed, then on 14th, 2021, the trial magistrate dismissed the application for review. So Peterson, the judgment and review went against him. So he filed an appeal. So, and is in appeal, Peterson is challenging both the ruling of 27/2021 and the review of 4th November 2021. So Juliet raised a PO. So a preliminary objection generally is raised by a party when there is defect in law, challenging the purely you are challenging the what the other party has done purely based on law, not facts. So there must be a legal thing here that Juliet is challenging on this appeal and a review. So that is how you interpret this question. So you are supposed to do a ruling. So you draft a ruling on this PO. So generally, this question is testing on whether you can appeal and or review at the same time. So can you review a decision then appeal on the same? So this is what the question was testing. So you go back to your civil procedure rules. So civil procedure rules, you go to the order that talks about review. And that order is order 45. You must know that. There's a difference between review and judicial review. So don't confuse. Review, you can apply for review when a judgment is given or a ruling, but judicial review is another thing, Order 53. Yeah, so you must understand your Order 45 very well. So I project the Order 45. What does Order 45 say of the civil procedure rules? Any person considers himself aggrieved by a decree or order of which appeal is allowed, but which no appeals have been preferred, or by a decree or order which no appeal is hereby allowed, and for whom the discovery of new important matter of evidence which after the exercise of due diligence was not within his knowledge or could not be produced by him at the time when the decree was passed or order made on account of some mistake or error on face of the record, or any sufficient reason desires of obtaining review of degree of order may apply for review of judgment to court which passed the decree of order. So a party who is not appealing from a decree or order may apply for review of judgment notwithstanding the pendency of an appeal by some other party, except where the ground for such appeal is common to applicant and the applicant, or when being respondent, he can present to the applicant court the case on which he applies for review. So, can a party review and appeal at the same time? So this is what the question was testing on. So you must understand your Order 45 very well. So, order Then Order 45.2. An applicant for review or decree or court upon some grounds of discovery or new important matter of evidence is preferred. If the judge who passed the decree or made an order is no longer attached to the court, the applicant may be heard by a judge. So this is what the question was asking about. And the answer is very simple. According to the interpretation of Order 45, a party who is have applied for review cannot at the same time apply for appeal. Yeah, that was the answer. So there is a case law here. Case laws are very, very important. Case laws are very, very important in civil litigation. If you can put them. So this is Civil Case 188 of 2021. The parties are HA versus LB. In fact, this case law is the basis of the question. So it is anonymized. This is the case law which was the question was based on. Exactly. This was an appeal on ruling of Honorable B. Kasavuli on 27 May 2021, 4th November 2021. Yeah, just like the question. So, a perusal from the record of these proceedings reveals that, so this is a statement of, concise statement of in a judgment. Reveals that 27 May 2021, the Learned Trial Judge made the submitted order against the appearance herein. Subsequently, by a motion of notice dated, the appearance sought to have the said orders reviewed. So, determination. So, what did the judge say? Of course, he quotes Order 45, Rule 1B, which I read earlier. Section 80 of Civil Procedure Act. Any person who considers himself aggrieved by a decree or order which appeal is allowed by this act, but which no appeal is preferred. So, what does the judge says? It is clear from the foregoing that the review remedy is only available to a party who has the right to challenge the decision in question by appeal is not appealing, or to whom is right of appeal. In other words, a person cannot exercise both the right of appeal and review at the same time. So the judge continues. I've jumped some paragraphs. You can look at it. So in this case, the appellant having sought a review order made on 27 May cannot now purport to appeal against the same. He can only appeal on the decision on 4th May. So the only decision that Peterson only need to have appealed the decision of 27th May 2021, not the review. So the orders or the disposition by the judge was that this was Odunga the Great. So he was barred from challenging the decision of 27th May 2021. So 27 May 2021 was the review. So he could not challenge the review, only the appeal on the decision that was made by the magistrate on 4th May 2021. Yeah. So that was the answer to that question. So he was barred from challenging the earlier decision. So I'm moving slowly because this was not a very easy question. And yeah, that is the answer. The question has never been tested again. It can be repeated in future because difficult questions are usually repeated. So I'm going to move to the next question. That is question 3, November 2021, civil litigation. And I'm going to read it. Mr. Waka was employed by company. So let me project it. Mr. Waka was employed by company at Water Limited sometimes in 2015 as a salesperson with a gross salary of 30,000. A dispute arose between the two directors of the company, Mr. Johnny and Mr. Gionia, on sharing of the profits of the company. Since Mr. Waka was a close friend of Mr. Johnny, there was suspicion in Mr. Adinojai that his co-director, Mr. Jokiain, could use Mr. Waka to take the company from him, as Mr. Adijona had been planning to get rid of Mr. Waka from the company. On 1st April 2029, Mr. Waka received a message from Mr. Adonaji through his WhatsApp platform that you are fired. Mr. Adonaji then instructed the non-answer security guard and Mr. Faja Fujo Uone, Mr. Waka should not be seen anywhere near the work premises. Mr. Waka stopped working or the company did not receive his dues or certificate of service. It's now 4 years since Mr. Waka stopped working for the company. He has just realized that he needs a certificate of service for his new employer. He also feels that the procedures that were used to lay him off do not meet the requirements of law, as he wishes to challenge the decision and compel the company to issue him with a compliant certificate for services and pay his dues. The workers approach you for renowned lawyer in town with impeccable record. The reason he gives you is not challenging the decision earlier is that he was under disability because there was a period after being dismissed from employment. He underwent extreme depression, whereupon he was diagnosed with bipolar disorder, and he has evidence to his effect. He has also confided in you that he did not believe that there was a message from Adija was sufficient, as there had been expected a formal letter from company which did not receive to date. Advised Mr. Waka on whether his prospective claim is term barred, and how he can mitigate the shortcoming if all. So, keywords: whether his prospective claim is time barred, that is a keyword. Then, how he can mitigate the shortcomings. 6 marks. That is question 3A. So, this worker, Mr. Worker, was fired on 1st April 2019. Then he went into depression. So he was prevented from entering the workplace. He did not receive the certificate of service. He went into depression. That's why he did not challenge the Nini. the decision, and now he wants a compliance certificate and to be paid his dues. So you are asked whether you can, whether his claim is time barred, then advise Mr. Waka on the appropriate forum. So this is the first time such a question is being asked from 2008. So what are the timelines to file a claim for employment if you are unfairly dismissed? The question is in section 90 of the Employment Act. Yeah. So that's the depression that he went against after he was fired in first. So he ought to have brought his claim by latest 1st April 2022. And this exam was being done in November 2023. So his claim was time barred as the Employment Act, Section 90. That is the first answer, part of the answer. So, can a limitation of time be extended? No, because extension of limitation of time usually happen on tort matters like accidents and such kind of things. So the courts have held that limitation of time cannot be extended on employment matters. So that is another part of the answer. Yeah, and there is a case here. So I want to share the case. So this case is called Peter Kadhi Kadhidi Kidome versus Rabotai versus Allied 2021. Miscellaneous application is 65 of 2021. So Peter Kadhidi Kidome brought an application under Section 90 of the Employment Act. Of course, under Article 41 on fair labor rules, the High Court, and Order 51 on that this cause be grant the applicant if institute proceedings against following a referee termination on 11/2017. So the applicant was arguing that the reason why he did not file his case within time so in fact when you read this case it has the same facts like the facts on the question. His employment was terminated verbally and gatekeeper and instructed not to allow him into the premises 11th January 2017. So he ought to have brought the case by 11th January 2020. But he did not do those. So the reason why it not being the case on time was that there was through his trade union, Kenya Chemical Workers Union, the matter was taken to consideration. Yeah. The question was whether leave to file the suit out of time could be granted. So the judge held that the time for conciliation did not stop there, the running of the time. So you can say after he got into depression, that did not stop the time. So this was Moni Kambalu. So leave was not granted. So this is a very good case to cite in this question. Yeah. Peter Kadidi, Kidome versus Laboratory and Allied Limited, 2021. Yeah. So that was the answer on A. On B, advise Mr. Walker on the appropriate forum. So how does it mitigate his shortcomings? He mitigates his shortcomings by filing a case at a petition saying his fundamental rights and freedom were infringed. Quote Article 41 on fair labor practices, because there is no limitation of time on when there is breach of fundamental rights and freedoms. Yeah. And the appropriate time forum is the Employment and Labor Relations Court. They can hear petitions. If you look at the Employment and Labor Relations Act, talks about that. So that was the answer. And you can the candidate, you can look at this case called Orepejeta Ranching Limited versus David Wajau Mohoro 2017, civil appeal number 42 of 2015. Now, not projected. It was saying that there was no limitation of time in bringing where there is breach of fundamental rights and freedom. And the issue here was a labor relation matter, unfair termination. So that is a case you can use there. Orepejeta Ranching Limited versus David Wajau Mohoro, 2017, civil appeal number 42 of 2015. A good case on B. So I continue to the next question, which is question 4. So question 4, November 2023. I'm going to read it. Violent is a well-traversed person. She works for humanitarian agencies and works entails visiting various cities in the world. Husband Victor is principal of Chanzu Mixed Secondary School. In one of many travels, Verrett bought a state-of-the-art dining set furniture for use in their matrimonial home at cost of 350,000 Kenya shillings. Sandri, her husband Victor, was involved in an road traffic accident. His mother vehicle KBU hit and injured Vaida. In a claim for damages from Victor, Vaida was awarded 250,000. In execution of the said decree, auctioneers have walked into Victor's home and proclaimed Violet's dining set. Advise Violet on any recourse she may have in law to save her dining set from amendment, auction, and procedure for pursuing his recourse. So, Violet is married to Victor. So Violet has this furniture, which was worth 350,000. So his husband knows someone. The case got to court. The person is ordered 250,000. He cannot pay. Execution is ordered. Decree is issued and the execution is ordered. So the auctioneer attached that sofa set. So Violent, does he have any recourse? So that is what the question is asking you. So does he have recourse? Yes. The recourse is objection. Objection proceedings. So the question was requiring you or the candidate or the student to talk about objection proceedings to execution by a non-party following a proclamation in execution of a civil judgment. Yeah, so that is the recourse in law. So how do you go about objection? You must understand your civil procedure rules and act. So the relevant rule is Order 22. Order 22, Rule 50 to 54. You can look at it later. Is the relevant rule on objections. Then Section 46 of the Civil Procedure Act. The application is a way of chamber summons, supported by affidavit. Then you can give a case law. A case law, an example is Sarah Abros Achieng care of Bodo Rafiki Hardware versus Dennis Ambrose Achieng and another. EKR. So, yeah, let me project that case. It's very, very important. I'm sharing, I want to share the screen. So, Sarah Ambrose Achieng versus Bodo Hardware was the appellant. Of course, you filed the chamber summons still in the case. So, and the parties, the same parties, then there's objector and the applicant. So what are your prayers? You can be told to draft. So what are their prayers? That the Honorable Court do make a declaration that the pre-crime items by the auctioneers belong to the objector as the legal equitable interest. So in this case, the objector was Robina Ngongo Onyango. He was saying that the items which were proclaimed by Ikimwanya auctioneers in execution decrees, yeah, were hers, do not belong to the judgment debtor. Yeah. So in the question you say the nani. So in answering the question, variant will say that this what the dining set does not belong to Victor, the judgment debtor. Yeah. So, and the case was successful. So that is how you answer the question. Yeah. So for you to get 10 marks, you must talk about his objection proceedings. You explain Order 22, Rule 50 to 55, Civil Section 46 of Civil Procedure Act. You say it's chamber summons, supported by an affidavit. You talk about the prayers which you have to pray. That what are the prayers in the chamber summon? The Honorable Court make a declaration that the proclaimed item, the sofa set, belong to the objector as the legal equitable interest on the proclaimed goods. Then another prayer that the Honorable Court do issue a permanent injunction to protect the declared legal and equitable interests of the objector. That the proclamation made by the actioneers be stopped. That the cost be made in the application. So those are the prayers you talk in an exam. Then you give one case law, and in that way you get your 10 marks. Yeah. So at this point, I want to talk about the applications which are brought by chamber summons. Because by default, civil procedure rules many applications are done by notice of motion under Order 51, but there are specifics application which are done by the chamber summon in civil procedure rules in civil procedure. So which are these applications? So leave to issue notice to a third party, Order 1 Rule 15, chamber summon. Apply for direction of the appearance of a third party, chamber summon. Substitution or addition of parties, chamber summon. Application for judgment against a third party in default of entering appearance, chamber summons. Application to furnish security on the person attendance to court, chamber summons. Application for a charging order under Section 52 of the Advocates Act, chamber summon. Application for enforcement of an undertaking, that is Order 52 Rule 7, chamber summon. Application to object to a tax master decision reference, chamber summon. That is Rule 11 Advocates Remuneration Order. JR application, chamber summons. Application to set aside an arbitral award, chamber summons. Or application under children matters, chamber summons. Application to the one we have dealt with to object to attachment of a property by an objector, chamber summons, for a person who has a legal right, amongst others. So it's very good in an exam, you know, the application brought by a chamber summons. Yeah. So I go to the next question. And I'm going to read it. That is question 5, November 2023. Civil litigation. Mwanaisha Upendo has a reputation for orderly conduct of the affairs. Let me mention that question 4 have been tested many times in the past. Yeah. So question 5, Mwanaisha Upendo had a reputation of orderly conduct of the affairs in her life. In year 2017, she deposited title document of her 2 prime properties in your law firm of Wakili Shupavu and Company Advocates for Safekeeping. The titles were in respect of ARA number that And then remember that the properties were valued at 5 billion. Her instructions are that she will come for the titles in person as when she needs to. In alternative, she will appoint a nominee to come for the titles when she needs to. Mwanaisha Upendo died in a tragic air crash involving Sabina Airlines on the morning of January 3, 2023. On January 2023, Juma Gaidi, a son of Mwanaisha Upendo, walks into your chambers with a letter bearing Mwanaisha's signature claiming that prior to her death, Mwanaisha had appointed her as a nominee for purposes of correcting the same titles. While your clerk was retrieving the title documents and prepared document to be signed by the recipient of the said titles for your records, Bwana Mkorofi, another son of Mwanaisha, walked into the chambers. He too had a letter signed by the late Mwanaisha appointing him as the nominee of Mwanaisha for purpose of correcting of the said titles. You tried to plead with both two sons to jointly receive the title, but they declined. Each of them claimed to be the sole nominee to receive both titles. As a seasoned lawyer, you know that there is an avenue through the court action for you to resolve this matter and extricate yourself from competing claims. Prepare the necessary pleadings that you file in court in the circumstances of this case. So this person, Mwanaisha dies, he has deposited the titles to you. Then the two of his sons come, each claiming that the titles was left to them. They are nominated to correct. So you don't know who to believe and who not to believe. So you are you are you are supposed to go to which avenue, prepare the necessary pleadings. Yeah, to resolve the matter. So this is drafting. So drafting, you must know the pleading, the document, draft it, and draft well within the timelines, and be able to answer the question well. So the question was testing on interpleader application. Yeah. So you draft an interpleader application. That is what the question was testing. Drafting is a skill which you must do practically for you to perfect. So interpreter application is guided by section 58 and order 34. So it is filed where there is a dispute between two people to a property held by a third party, and the third party does not know who to give between the two. So the application is due the originating summons. So that is what you draft. In the originating summons, you must say the following, which is contained in Order 34, Rule 2. That you have no interest in the subject matter, you have no collusion with the two parties who are disputing, and you are willing to transfer or give the subject matter which is being disputed to the parties after the court action. Yeah. So it's originating summons and supporting affidavit. That is what was required for you to draft. Yeah. So they are have an if you go to the website, there is a sample interpreter application. www by exam preparation website. My website there's a sample interpreter application. You can look at how it looks like. Yeah, under the civil litigation notes. So this question have been tested many times. Yeah, it's a repeated question. It is have been tested 2 times in the past. So it was a new, not a new question, and it was an easy question to do. So I go to the last question of the day. Question 6, November 2023. Civil litigation. And I'm going to read it. The taxing officer, Honorable M. Tasia, sitting as the Deputy Registrar of Kisaki Employment and Labor Relations, struck out your advocate's client bill of course with costs via ruling that she delivered 3 days ago. In her ruling, she affirmed the client's responded argument that there was a fee agreement between her firm and client on the legal fees since she did not have jurisdiction to tax the bill of costs as drawn, which was sought and sought for 4.5 million against the client. Among the documents she relied on in her ruling was an email correspondence between you and the client, where your client alleged wrote you as follows. Dear counsel, I trust you are well. Please refer to our meeting yesterday in your chambers. I wish to inform you that I have accepted an inclusive fee of 900,000 as proposed by yourself in the meeting, payable in 3 installments each. Kindly confirm the foregoing by acknowledging receipt of the email. You don't dispute that there was such a meeting between you and the client, although it is your position and you never responded to the client's alleged email to confirm the terms of engagement. Here there was no fee agreement. You wish to challenge the taxing officer ruling as a matter of urgency, noting to the strict timelines to be adhered to. As counsel had doing the brief on behalf of your firm, draft a legal opinion from a managing partner stating the reason why you wish to challenge the ruling and the procedure involved. So, so you want to challenge the decision of the taxing master. So you are drafting a legal opinion. So you must know how to draft a legal opinion from your legal writing and drafting class. And because this is internally in a firm, you do an internal memo. A legal opinion is form of an internal memo. So, you wish to challenge. So why are the reasons of challenging the ruling? The reason are although the client wrote you an email, you did not respond because there must be an offer and acceptance for there to be an agreement. So that is the reason. So what is the procedure? Procedure, you discuss order, paragraph 11 of advocates remuneration order. So I can open that one. So advocate's remuneration order. So I'm projecting the advocate's remuneration order. Paragraph 11 has the procedure. So 11.1, should any party object to the decision of the taxing officer, he may within 14 days after the decision give notice in writing to the taxing officer of the items of taxation to which objects. So 14 days, the advocate writes to the taxing officer. So then the taxing officer, 11.2, record for reasons of his decision within 14 days. Yeah. So he has 14 days, the advocate, to write to the taxing officer. So 11.2, after receiving the reasons of the taxing officer, he has 14 days to apply to a judge with a chamber summons and serve other parties and set out the grounds of his objection. Of course, the grounds you have already talked is about that there was no agreement between the client and the advocate. So the taxing officer ought to have tax the 4.5 bill of costs. Then after the decision of the judge, High Court judge, then with leave, he may apply to the Court of Appeal. That is 11.3. So the High Court has also has power to enlarge time. If 14 days have passed and the taxing master has not given the decision, or after receiving the decision of the taxing master, 14 days has passed before a party goes to a party challenge the taxing officer decision through a chamber summons. Yeah. So challenging the decision is a miscellaneous reference. Miscellaneous reference by way of a chamber summons. Yeah. So you draft miscellaneous reference, draft the appropriate pleading you intend to file on the taxing ruling. That is question 6B. 4 marks. So you draft a very small pleadings or document. So the applicant is the wakili. And the respondent is the client. Chamber summons. So into bracket, you say Rule 11(2) of Advocates Remuneration Order. So let all parties concerned at chamber summon is let all parties concerned. Notice of motion is take notice. So what are your prayers? That the Honorable Court be pleased to vacate and set aside the entire ruling and reasoning of the Honorable Taxing Officer, Honorable M. Taisia. So date is not given in the question. So you guess a date in which he refused to tax the bill of costs, saying that there was an agreement. So that is one of the prayers. Then that the cost be provided for. So which application is based on the following grounds? You put your grounds there. You can put 1 and 2 or 2. Then you are done. Don't write so much because it's 4 marks. Then you drawn and filed by to be served upon the advocate, drawn and filed by the advocate to be served upon the client. Then you put the penal notice. If parties have do not appear at time and place above mentioned, such order will be made and proceeding taken as the court may think just and expedient. So remember always a penal notice. Remember the penal notice in chamber summons. Notice of motions. Yeah. So that was the answer to question 6. This kind of the question has never been tested, but it's related to question 3 October 2023. But in that question, there was seeking for leave. The drafting that was needed to be drafted there is miscellaneous reference chamber summon to seek leave to challenge the decision of the tax master because it has the time has elapsed. The time had elapsed, the 14 days. So you can look at that question. The the video is uploaded on the YouTube channel. So that is how this paper ought to have been answered. Of course, question 1 was easy, judicial review. Question 2 and 3 were not easy. Question 4 was easy, repeated many times, 2 or 3 times in the past. If you look at the Q&A, you will see. Question 5, interpreter applications is repeated, easy. Question 6, also easy, not hard. So a wise student could have chosen those questions. Then know which one to avoid between question 2 and 3. Because you only avoid one question in a paper. You do 5. Compulsory 20 marks and another 4, 40 marks. And the questions are 6. Yeah. So you have come to the end of this November 2023 question and answer. Thank you very much for watching the video. Subscribe to the YouTube channel. Go to the website and purchase some papers via exam preparation website. Join the WhatsApp group. Yeah. I add you to the WhatsApp group through my contact 0719 47340. So the next video and the final one will be on April 2024 civil litigation, which I'm also going to do and upload. Thank you for watching. God bless you. And after watching this, may you have understanding and pass your exams.